Assalamu alaikum. Welcome to the Sharamon law classes. Friends, we are going to start our lecture. And today our lecture is related with the dishonor check or fake check. So in this class we will discuss in detail about the dishonor check or fake check. So whenever any individual who issues a check towards any other person or other individual for the repayment of loan or other obligation, and the person on whose name that check has been issued, he goes to the bank and submit that check in his account, and the concerned bank official or manager return that check along with the dishonor slip. So we can say that the check is dishonored, and the person who has issued the check, he has committed the offense which is punishable under the Pakistan Penal Code under section 489F PPC. So friends, section 489F was inserted in the Pakistan Penal Code through the Criminal Law Amended Ordinance, which was promulgated in Pakistan on 25 October 2002. And now section 489F is the part of the Pakistan Penal Code, which is punishable up to 3 years with fine or with both. So in this lecture I would like to try my best to touch all that parameters, all that related things which are associated with the dishonor or fake check. So first of all, I would like to talk about that what is the offense of 489F. So the offense of 489F is this, that when any person issues a check dishonestly with dishonest intention towards the repayment of loan. And in this connection, I would like to quote one judgment of the Lahore High Court, that is NLR 2004 Lahore, page number 614. And in this judgment, the Honorable Lahore High Court held that whenever 4 parameters are fulfilling, so then one can say that the offense of dishonoring check has been committed. And these 4 ingredients, I repeat one by one. Number 1, to issue a check dishonestly. Number 2, the issuance of the check is towards repayment of a loan or other obligation. And number 3, that the check is dishonored from the concerned bank. And 4th, that the check is issued with dishonest intention. Means the dishonest intention is the very essential element which shows the mens rea of the person who has issued the check for the repayment of loan or other obligation. There is also a judgment of the August Supreme Court, and I may say the citation of that judgment before you people. You should note that is ACMR 2005, page number 306. Once again I am repeating, ACMR 2005, page number 306. In this judgment, the Honorable Supreme Court put forward 2 parameters, and when these 2 parameters are fulfilling, so we can also say that the offense has been committed. Number 1, to issue the check. Secondly, to dishonor that check from the concerned bank. And in this judgment, the Honorable Supreme Court has held that only to issue the check in the name of the other person is not an offense until and unless it is not dishonored from the concerned bank. Now, this was about the offense of 489F. But now the question is arising that whenever any individual issue a check, how the other individual against whom a check has been issued, how he will lodge an FIR against the culprit who issued the check. So, for this purpose, this is the duty of the person against whom a check has been issued and he has dishonored that check from the concerned bank in his account, that he shall proceed to the police station and submit a written application to the concerned police officer, and whereby he will claim that I had such and such business relationship with the person so and so, and he issued a check to me, and then I went to the concerned bank, submit the concerned check in the bank, and then my check has been dishonored and the person has committed the offense. And he will also write down in that application that an FIR may be lodged against the culprit, against that person who has issued the check. So this is the duty of the concerned police officer, that then and there he will lodge an FIR against the accused person. But there is also another question, that where that person will lodge the FIR. So he will lodge the FIR in the concerned police station where the check has been dishonored. This is a very technical point. I will explain this with an example. Suppose there was a business transaction between the two persons, that is Mr. A and Mr. B, and they enter into a business transaction through an agreement in Lahore, and A has issued a check in favor of B, but B came to Rawalpindi, and in Rawalpindi he dishonored his check from the bank where his account was there. So now, instead of this, that he will proceed to Lahore and will submit application to the concerned police station, this is wrong. He will proceed in Rawalpindi where the bank is situated, in that jurisdiction he will go to the PS, to the police station of that place where the jurisdiction of that PS is there, and then he will proceed over there, and in Rawalpindi he will lodge an FIR. So keep in mind that this is very technical ground. And if the SHO or the police officer deny to lodge the FIR or lingering the matter on one pretext or the other, so then the next remedy available to that person to take the photocopy of that written application and go to his counsel or go to his advocate, and through his advocate he may file a petition under section 22A, 22B CRPC, and then the concerned judge, that is the district session judge or additional district and session judge, who is also called is Justice of Peace under section 22A, 22B, he will dispose of the application, the petition, and on that petition the honorable judge will issue directions to the concerned police official to lodge an FIR against the accused person. And then this is the duty of the concerned police officer to lodge an FIR. And if again he is lingering the matter, so then the said person can again knock the door of the said court through contempt petition, and then the court will order to lodge the FIR. But this is also important at this stage, that when the district and session judge or additional district and session judge, who is also called is Justice of Peace, dismiss our application, so what is the remedy available to us, how we will proceed? So then two remedies are available. Number one, to lodge and file writ petition in the concerned High Court. Secondly, to file criminal revision. So in Pakistan, both are going side by side. In certain places, means in certain provinces, just like the province of KPK in the Islamabad capital territory, we file writ petition. In Punjab, we file criminal revision. So then the High Court will order for lodging the FIR. Friends, keep in mind that the offence of 489F is exclusively triable by the Court of Magistrate, and the punishment prescribed is 3 years. And whenever the judge, the magistrate is giving punishment, so then the accused person can go to the Session Court, then High Court, and then to the Supreme Court. And whenever the magistrate acquit the person, so then we will move directly to the High Court. Keep in mind, this point is very important, that whenever the Honorable Magistrate acquits the person from the charge, so then we will directly move to the Honorable High Court and we will file criminal appeal under section 417 CRPC. So this is very technical point, and we will file that appeal against acquittal in the Honorable High Court. So this point is also important at this stage. Now, this was about the lodging of FIR plus punishment and then appeal. Now, how to file application for bail. So this is also important that I should also discuss at this stage, that this is not a, we can say that this is not a discretion, this is not a, the case is not a bailable offence. The section 489F is not a bailable offence, but it is also not falling in the prohibitory clause. So you may claim bail in the Court of Magistrate or Session Judge, then High Court, and then Supreme Court, when certain grounds are available. And similarly, if the amount is less, means when the amount is less than 5 lakh rupees, so normally the magistrate, when some grounds are also existing, granting the bail, when the amount is more than 5 lakh rupees up to 10 or 15 lakh rupees, so then the Session Court is granting bail, and when the amount is exceeding from 15 or 20 lakh rupees, so then these Honorable High Court and August Supreme Courts are granting bail. But keep in mind that we may not claim bail is a matter of right, but whenever certain grounds are existing, so on that existing, it is on the discretion of the court, whether it's the Court of Magistrate, Session, High Court or Supreme Court, to grant bail to the accused person. So this was about the bail matter. Now there is also a question that how we will recover our amount from the person. So there is Order 37 CPC. In Order 37 CPC, we may file suit for recovery, and we may file that suit not in the Court of Civil Judge, but we may file that suit in the Court of Additional or District and Session Judge, which is also known as summary trial. In Order 37 or Order 37 was inserted in the Civil Procedure Code in the year 1972, and it's a summary trial, and the court is proceeding very speedily in such like cases, and normally within 3 or 6 months the court is deciding the case, either to degree the case or dismiss the case. And whenever we are filing suit under 37 CPC, so on the first stage the court is issuing direction to the defendant to submit written reply, and also to seek leave, to grant leave, and within 10 days, and the court may order conditionally to submit surety bond or unconditionally, and that surety bond is normally equivalent to the amount which is that in the check, which is claimed in the suit. Similarly, when that person is proceeding to the High Court, so in the High Court the matter is very technical, and that person has to submit surety bond, that is the bond, and the bank will take a guarantee, means he will tender bank guarantee in the High Court. So from this it's clear that the matter related with check is the courts are considering this is a harsh matter, and normally punishment plus recovery is there. And when that person is when a court is passing degree against that person, and until and unless that person is not paying the amount to the person, either he will remain in jail or the court will auction his property after filing the execution petition. So with this I conclude my this lecture. Inshallah, with the next lecture once again I will appear before you people. Bye for that time. Allah Hafiz. Thank you.